Yesterday in Utica, New York, one state prison guard was convicted of murder and two were acquitted for killing Robert Brooks at the Marcy Correctional Facility last December 9th, 2024. I'm JB Nicholas, and I'm a journalist who covered the trial for the freelancenews.org, my news website. I want to talk about the irregularities that I saw throughout this trial that I think infected the fairness of it and led to the acquittal of these two officers of murder. So the first irregularity that I witnessed during the trial was the defense lawyers were allowed to make a number of arguments that were based on evidence that was not in the record or didn't exist at all. And some of them can fairly be characterized as straight up lies and disinformation that the defense lawyers, the lawyers for Kieffer, Kingsley, and Galiher were allowed to spew to the jury without objection from the prosecution and without correction from the trial judge, who was Robert Bauer, a former Oneida County prosecutor. So I'll give you an example. In one of their arguments to the jury, David Longaretta, the lawyer for Nicholas Kieffer, argued that when Farina stuffed a rag down Brooks's throat while he was torturing him before he killed him at the Marcy Correctional Facility, Longaretta argued to the jury that he was just wiping Brooks's face with the rag. Now, everybody knows, just based on looking at the video, that that's false. But Longaretta was allowed to make this comment without any evidence whatsoever in the record. And similarly, all the defense attorneys argued that Marcy was a dangerous place. And it was so dangerous that these, powder puff snowflake guards, just patently outrageous, needed to protect themselves from a handcuffed prisoner who was 145 pounds, 5'7", and handcuffed behind his back. So there was no evidence put in the record about how dangerous Marcy was, a medium security prison compared to other prisons. Now, let's compare that, for example, with a trial that's going on right now in Brooklyn of a guard, a CO, a federal correction officer, who chased a guy through the Brooklyn streets who he thought was trying to help smuggle contraband into the jail. So he actually shot at the car by the Brooklyn Bridge, and he's on trial in federal court. And the defense attorneys in that trial tried to submit submit this evidence that the jail in Brooklyn was insane, and you can't divorce that reality from the perception of this officer. And that got squashed right away by the trial judge. But in this case, in Brooks's case, Judge Bauer allowed these attorneys to make these false arguments without any basis in the record. So that's one of the main, this happened repeatedly with other issues. I'm just giving you an example. So that's one of the main irregularities that I witnessed in the Robert Brooks murder trial. Now, the second irregularity that I witnessed occurred on the first day of jury deliberations last Wednesday. So the judge instructed the jury on the law and let them retire for deliberations for about a half hour from 4 to 4:30 last Wednesday. And after 4:30, while the jurors were leaving, before the jurors, let me just back up a little bit. Before jurors in a criminal case leave for the day, the judge instructs them not to discuss the case with each other or anybody else. Deliberations have to happen in the jury room for a number of reasons, and they can't be having these extracurricular deliberations, right? So they're instructed not to talk about the case with anybody else. But yet, here we are on the first day of jury deliberations in the parking lot, as three jurors are walking to their cars, they're talking about the case. They walk right by me, talking about the case. And not only are they talking about the case, one of the things that I heard them say was that it looks like, one of them said to the other two, it looks like we're going to be here till next week. Now, that's not really the substance of the trial, right? So I didn't think it was like a big thing at the time. So I didn't mention it to anybody. And besides, I kind of prefer to give people the benefit of the doubt, right? So I don't mention it. But I'm mentioning it now because it raises questions considering all the other irregularities that I saw. So what this comment tells me is immediately at the start of deliberations, there were two factions in the jury room who were firmly embedded in their beliefs. One faction believed that all the officers should be acquitted, notwithstanding the video and the evidence, okay? And that's called jury nullification, and that's not supposed to exist in American law. A prime example of jury nullification is in the South during Jim Crow, that the killers of black men were routinely acquitted by juries, right? And this is sort of where federal prosecutions come in. You know, if a jury does this racist jury nullification, then the feds can come in and prosecute you. So that's what jury nullification is. Now, it can be used, on the other hand, it can be used for things that other people might consider good. Like, for example, selling marijuana, right? When that was illegal, sometimes people would sit on a jury and just refuse to convict for selling marijuana. So that's another example of jury nullification. It has both sides. It's a controversial issue. And so so there were two factions right off the bat. One that believed that none of them should be convicted, and the other faction believed that there should be convictions. So these two factions were at loggerheads from the start. The third irregularity. That, what I just said about the jurors talking to each other, that the importance of that, the significance of that didn't really become clear to me until after the trial when Kingsley was convicted, but Galiher and Kieffer were acquitted. So what that tells me is that's a classic compromise verdict. That the only way to get out of that jury room for these guys, in their minds, was we're going to convict Kingsley because he's on video choking Brooks, but we're going to let these other guys go. And the reason I say I believe that to be the case now, I've done a lot of fact-based reporting. I'm an investigative journalist. Most of my reporting is all based on fact, but right now I'm going to editorialize a little bit. So this is extrapolation from the facts as I witnessed them. So, and this is based on my experience covering criminal cases going back to 1991, okay? So when the jurors come out of the courtroom, come out of the courthouse after the verdict, the press typically asks them questions. There's a custom. The press can approach jurors. In New York City, they come out of the DA's office and walk to the subway. They don't have an escort or anything. Now, in Oneida County, they had an escort to the parking lot from court officers. So right away, journalists are at a disadvantage because jurors are reluctant to talk in front of the police for fear that they might make them displeasure the police. I'm not even joking about this. So the first group of jurors came out, about 9 of them, and I approached them and I said, hey, I'm a journalist. The public is interested in how you reached your verdict. Can you explain it? And everyone just sort of looked down at their feet. And then suddenly, a young Latina woman stopped in her tracks, turned around, and was hostile and said, we don't want to talk to you, leave. As if she was speaking for the other jurors. So this hostility, and I reacted to that simply by saying, you know, my name is J.B. Nicholas. I publish the Freelance News. You know, please feel free to contact me at your will. I'm just going to walk with you here a little while, you know, in case any of you change your mind. And that really upset that woman. And you would think, her being a young Latina, that maybe she had favored convicting the police. But she was really angry. And I couldn't, you know, I've covered so many trials. I've never encountered hostility from a jury quite like this before. And so it raises a lot of flags, and I'm putting it all together now for you. So then the remainder of the jurors came out, a smaller group, 5 or 6 of them, also under escort. And This time I wasn't alone. Some other reporters had come out of the courthouse at that time and were moving to catch up with the jurors. And again, jurors were hostile. Not only would they decline to talk, they were outright hostile. One reporter from the New York Times asked a journalist, another youngish guy, red hair, looked like he might, play video games and smoke a lot of marijuana on the weekend or something. And, he asked him if he was happy with the verdict, and his answer was, what the fuck do you think? We deliberated it. Okay? So, and it didn't help, by the way, that a court officer was intervening, and he shouldn't have intervened, and he was telling jurors, you don't have to answer their questions. Now, if you're a juror and you're being escorted to your car by a court officer, and the court officer is saying you don't have to talk to them, that's pretty much tantamount to an order not to talk to them for the average juror who's not used to defying police authority, you see? So, lot of irregularities and red flags that I would call them about the Robert Brooks trial and the way it was conducted. Now, the last thing I'm going to mention is that I made a request for copies of the trial exhibits to the trial judge, Judge Robert Bauer, the former prosecutor, and he denied the request. These are public records. Trial exhibits or public records. Courts across the nation are unanimous in their judgment that the evidentiary exhibits in a public trial are public records that the public has the right to access. Yet Judge Bauer suddenly decides that trial exhibits are government secrets. So there you have it. There's my combined report and sort of analysis. Consider this a news analysis on the Robert Brooks murder trial and what led to the verdict convicting one of the guards and acquitting two of them. J.B. Nicholas for thefreelancenews.org. Please check out my website and donate if you have a chance. We run on donations here. Thank you very much.